Let's go now and talk to Josh. You're on the air, Josh. Go ahead.
Yes, sir. Good afternoon.
Hey.
A question for you. First-time home buyer. I recently purchased a home with my wife and I. The mortgage is exclusively in my name. She had a prior bankruptcy, and we didn't want any of the credit mixing.
All right.
The house is titled to both of us.
Got it.
Husband and wife, Joshua, what have you.
Yep.
So my question is this. In terms of asset protection, in terms of having, the best protection in the eyes of the law, considering a homestead and everything, did I title the property the right way? Is it better to have myself and my wife on there, or should I have titled it to just myself?
Josh, I think it is best to title it in both of your names, okay, because that's what most married couples do. And as far as creditors are concerned, remember that here in the state of Florida, your home is protected by the Florida Constitution, which says that no creditor may take away the home of an individual. So whether the home was in just your name or the home is in both your names, if you get sued for $1 million for doctors, hospitals, automobile accident, they are not going to be able to touch your home. Does that answer your question, Josh?
Yeah, it certainly does. And we're also having a child here very soon, and we're starting to look at getting an asset protection scheme together. I know it's an advanced move, but I've heard of people titling their home, in a trust and things like that. Is that something that's way down the road, or something that we need to look at soon?
Josh, first of all, the vast majority of trusts that you hear about there, living trusts, people do not and should not put their homes into the trust. I just told you that every individual's home is protected from creditor claims by the Florida Constitution. If your home is owned by your trust, it is no longer owned by an individual. It is therefore subject to creditor claims. Josh, in my opinion, you need to keep it more basic than that, Josh, and that is that you and your wife need to have a will with your new child. In that will, you're going to name a guardian who would be the parent to that child if something happened to both of you. And in that will, you're going to set up a trust for your minor children. So if something happened to both you and your wife, your wealth will not go to your child outright. It will go into a trust for his or her benefit. That's where I think you need to be heading with this, Josh. My office would be pleased to assist you with it.
Certainly. I appreciate the help.
You're welcome, Josh. Bye-bye. By the way, when I do wills for people, I typically do a package of 4 documents, all very important. I do the will itself. I do a living will declaration where you ask that you not be kept alive by artificial means. I do a durable power of attorney for health care and a durable power of attorney for financial affairs.